The April 16th meeting of the Compliance and Amendments Committee is now in session. We have the first item, please.
First item, call to order, roll call, and agenda changes. Chair Kanata.
Here.
Chair Kanata here. Member Highland.
Here.
Member Highland here. Member Hinsey.
Here.
Member Hinsey here. We have a quorum.
And no agenda changes, I'm assuming?
Not to my knowledge,
Okay,
no.
great. Next item.
Next item, item number 2, approval of the December 18, 2018 Compliance and Amendment Committee meeting minutes.
Anybody have any changes?
None that I can see.
Member Hinsey?
No.
Okay, do we have a motion?
Take your
Over the
time.
minutes. Okay. Sorry.
Hinsey moves, Highland second.
Yes.
Sure.
Public comment on the motion to approve the minutes? Seeing none, we take it by acclamation. Thank you.
Okay.
Okay, next
Number
item.
3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Is there any public comment on anything? Seeing no public comment, we'll move forward. Next item.
Item number 4, file number 18049, complaint filed by Robert M. Smith against the Fine Arts Museums of San Francisco for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and/or complete manner.
Okay, so this issue is purely compliance. The case was heard and decided. The Fine Arts Museum agreed to start providing documents with 7,000-ish by this week and then continuing on a rolling basis. So, Mr. Smith, what have you got?
If I may, I'll do this in a journalistic way. When? I received the documents this weekend, so I've had one business day to look at them. I thought there were going to be 7,000 documents a week for 10 weeks. I must have been wrong because it got to be only one batch of 7,000. Actually, I haven't received 7,000 documents. I've received 7,187 pages. The pages appear largely to be communications, if you recall my lingo, from Silo 2 to Silo 1. They're communications from people in Silo 2 to Silo 1, which in any event is exactly what they said they would send me. Rather than sending me, if I can. Right. So that all they're giving me are communications between Silo 2 and Silo 1. How they've reached that limitation, I have no idea. It's wrong, but that's what they're doing. They've been redacted, but with no legal basis that I can make out for the redaction. Instead of providing a basis that justifies each redaction, they supplied a one-time explanation, and it was dead wrong. And I responded to them saying, this is completely wrong. They cited, incredibly to me, in support of their position for redacting things to authorities, and you can see, I guess you can see on your screens, that the authorities they cited are exactly, stand for exactly the reverse proposition. The authorities say they stand for the public's right to know, not for privacy. They cite the government section 6250 and the Sunshine Act.
Mr. Smith, let me interrupt you there. Let's go a little more slowly. So my memory was they were going to send you emails, not necessarily documents, and I think that word documents is misplaced there. So as I understood at the last meeting, there was 70,000 emails, of which you're going to get on a rolling basis roughly 7,000 per batch. Is that not what you recollect?
Yes, I don't know about
that's what we
emails, but the word emails, but I took it to mean...
That's what I remember.
Because I think it was only email. It was stated only the word emails, correct?
Yeah. Okay.
So...
Right. So
Yeah.
So let's just get that. Let's talk apples to apples. So can we be in agreement on that? Is that what you remember? I think we had a. Do we have like a in order determination? I think that language is in there. So I just want to get that before we get into the nitty gritty of redaction. Let's get that down first.
Victor?
Because it was 70,000 emails, and then he was going to get 10% of the 70.
70,000.
Thousand.
So 7,000. That's what I.
Yeah.
So I just want to get that out in
Directing
the
the-
open first of all before we
Yeah,
rabbit holes.
Though these haven't been issued yet, we just need to go with what's written in the minutes.
I'm looking at that. Yeah. So I'm pretty sure that was the algebra. 70,000 emails, you get 10% on a rolling basis. That's 7,000 emails. So let's go back. What did you get this weekend?
I got 7,187 pages. I can't tell. Yes, because when you plug in the thumb drive, it gives you the total of the pages.
Okay.
I didn't count them.
Okay. And were those individual emails? What were they?
Well, I haven't been in one day. I wasn't able to go through every single item, but there were a large number of emails. But I'm confused. Are you saying that the only thing I'm going to get from the museums are emails?
No, that's not what I'm saying. I just want to clear up the emails and the documents.
Oh, okay.
Issue
Okay.
to start with.
So I
because-
wish I could answer your question, but I haven't had a chance to go through every single thing. And frankly, I was moving so quickly that I couldn't tell you if something was an email or
Okay,
was
so let's-
something else.
Let's just stop you right there. I think member Hensley had something.
Yeah, so just to clarify, I believe our agreement was 10% of the 70,000 emails by today. So that would be 7,000 emails by today. Not necessarily documents, but emails.
Perhaps we can hear from the respondent.
Yeah,
and see what they say.
is somebody here from the Fine Arts Museum? And
Yeah.
could you come up and tell us what was sent and give us information on the redactions and the reasons for the redactions, please?
Yeah.
Yeah, if you could yield the podium. Thank you.
Hi.
Mr. Smith, take a seat, if you would.
Let me get my...
Okay. Great.
Melissa Powers for the museums, Fine Arts Museums. We sent Mr. Smith a thumb drive that had 7,187 combination of emails and their attachments. So were there 7,000 individual emails? Probably not, but many of them had numerous attachments, but in total on that thumb drive was 7,187. In terms of where we're getting the COFAM to FAMSF, this is where I think, and I actually hope we can maybe narrow the scope here tonight, this is file number 18049. And the complaint that was pending and that became this whole conversation of how many emails are out there, how many documents are out there, was in relation to part 3 of that complaint. And it's within this tonight's agenda documents numerous times. It's been repeated numerous times, and in our input for the several times we went in front of the compliance or the complaint committee. But every time, like this email that he's flashing up there was in relation to a question he asked me for a new request that he sent the day after or the week after we had our last meeting. So if we can just streamline this instead of a grab bag of every single correspondence we have with Mr. Smith.
Well, all we're trying to do
Exactly.
tonight
Is the answer is yes.
is to make sure that the Fine Arts Museum is in compliance with what was agreed to at the full hearing, and that
we
was
are.
to start sending 10% of the emails and attachments by this meeting, and to continue to do so until the number 70,000 was supposed to be reached.
Right. So the first part is, yes, we have done that. So the very short answer to the question of has the museums complied, the answer is yes. As far as the number, at the night of that hearing was based, this number 70,000 was based on a PowerPoint presentation that we had put in during, I think, one of the October committees when our IT had looked at everything possibly associated with the city account, with an email to a city employee. Since that time, they were able to create an algorithm to narrow it down to emails that have our famsf.org domain, and then based on what the complaint is, the COFAM to FAMSF, because that's what he asked for, it narrowed it down significantly to about 32,000. So where we stand now is we have about 24,000 more documents to review. And we stand here saying, at this point going forward, we'd like to put the barometer more in terms of number to review, and we will comply with, we represent that we, by the next committee, will have reviewed at least 50% of that, and then on, and provide him what we believe is disclosable. I mean, believe me, we have been working nonstop to get this done.
So what percentage of these emails were redacted and why? What's the reasons for the redactions?
To be honest, I'm not sure off the top of my head the amount of the 7,000. I mean, there were a lot. It wasn't 50%. I'm trying to picture it right now in my head, but the basis for redaction were mainly personal privacy. Such examples would be statements in the emails referencing medical conditions or reasons for being out sick, home addresses, personal emails, personal phone numbers, personnel matters involving counseling, performance, reasonable accommodations, statements in the emails discussing consultation with legal advice from city attorneys, and other information that falls under the privacy domain.
Okay, any other questions for any party?
Just to backtrack a second, so I like what I'm hearing, the fact that you guys have done further research. You've narrowed it down to, you think, now 32,000. And by my math, you've provided almost 40% or about 20% of that already, which is double what we'd asked you to do based on the original number. I'm trying to go back to our original notes or OD. It'd be nice to kind of have an index of delivery of what's going to come. Did we not put that in the instructions?
Now we just said,
because we didn't have it, we didn't know what the number was, right?
Yeah.
Okay.
but
you're right.
It would be nice to know where we are. So, now,
but if they go half of or whatever percentage by the next meeting, that's another 2 weeks. So it kind of falls into 2-week cycles.
Okay, I think
it seems like.
I think I remember we talked about 2-week cycles. Do you remember that, Ms. Powers?
Well, what I recall is in the beginning we talked about there was sort of a weekly type cycle thing, and then I think at the end when we realized we were talking about such a large number, that's where in the end the gentleman that was sort of sitting on this side started the conversation about let's just do 10%. So since these, and we were only 6 weeks away from this meeting, which now I realize we're, I think, 8 weeks away from the next meeting. I think the next meeting is in June. So in our...
Well, that's
That's the next meeting in this committee. We're talking about, I believe, the next meeting in the full task force.
right. If you can provide additional documents by the
I tell you what, I think we need to establish a calendar right here and now.
Yeah.
Let's do that. Let's accept your 32,000 as the number. You've provided 7 of them. When do you think you can give Mr. Smith the next 7,000, let's say?
Well, and this is where I'm cognizant of the fact that some of them are going to require greater review, right.
So try and, if you're going to hold the hardest ones to the end, and obviously he has to catch up and read on them. So, would it be fair to go, 2 weeks, 2 weeks, and 2 weeks, or 2 weeks, 2 weeks, and 4 weeks for the last batch? Because that might be harder to get through. Is that a reasonable format, reasonable timetable? I'm just trying to benchmark this a little bit so that we're all on the same page and we're not.
Could we do it, since today's the 16th, and could we do it by a month to do another production within a month, May 16th?
I don't really care about the committees. I just want dates down, and then whatever committee follows that date, we
But if
can.
you're talking a month, what percentage would the next batch be? I mean, if we get into a month time frame, you're looking at, a quarter to produce these.
I think our timelines are a little more aggressive than that. So I think.
Yeah.
I think.
Can you get the next batch by the end of April?
Let's say May 1st. 2 weeks.
Well, what the barometer that we'd like to use at this point is how many we can review. It was easy to say, or easy relatively to say 7,000 when we knew we had 70,000. Well, we thought we had 70,000.
Right.
I don't want to necessarily promise 7,000. And I understand you'd be like, well, why wouldn't you have 7,000 out of 32,000? But in terms of, like you're suggesting that it's harder to review certain ones. There's a lot of attachments. So it's the rate of review can slow it down.
So are there 32,000 left, or is that 28,000?
No, there's about 24,000 left.
Okay. So how about this? How about 5,000 on a 2-weekly basis until you're done? That gives you
5,000 provided or 5,000 reviewed? Because 5,000 every 2 weeks is a lot. Because you get, for every one you review, you potentially and realize we don't have like high speed
How about
programs.
this? Let's aim for 5,000 every 2 weeks, but you can just notate what you actually deliver to Mr. Smith. And I think as long as you get something and there's see an effort on your part, we can work with that.
Right, because I stand here tonight saying I'm not sure we can give you 5,000 documents in 2 weeks. That's a lot because you have to account for reviewing the documents, potential redactions.
Problem is, if we say 3,000 in 2 weeks, that's 10 months until we get them all. That's just too long. I mean, this.
Oh no, believe me, we have every intention of
So let's-
trying to wrap this up.
Let's do 5,000 every 2 weeks. Let's aim for that, and then if you can let our clerk know what you are providing on a rolling basis, just copy her on what you send to Mr. Smith and say, here's 3,200 out of the 5,000 we aim for by May 1st, and then here's another one by May 15th. That would be good faith, I think.
Okay.
Yeah.
And that'll, I think, give him enough material to at least on a rolling basis keep reviewing. But what I want you to be aware of is that we're setting an end date here as well to get it all by, just doing the math, what is it, 5 times 2 weeks? So that's 2.5 months from now, we'd like it all done.
Let's even do 3 months.
3 months, yeah,
The middle of July.
before everyone disappears
And
for the summer.
again, if it's impossible to do, but a good faith effort, there has to be documents going out.
And you
Right.
started on a good pace, so we realize that you're trying to work on it. So let's get that into the record. Maybe we can get that timeline. I mean, I think you understand what we're saying. I just want to get that in the record. And I think a second part of this is to talk about redactions.
Yeah.
Right, because I can tell you, for instance, after the first, that we have stuff due May 1st, then May 15th, and then that 2 weeks following, we're going to have a little bit less review support based on just schedule. So, like, that chunk of time might be really
And
harder.
just note that in your communications to Mr. Smith and us, just say, because we had 2 people on vacation, we were only able to get to this, but they're back, and we're going to try and catch up in the next 2 weeks. That's okay.
Okay.
All right. So,
Okay.
So how do we want to talk about redactions? Because
I think we talked about that in the order of termination, did we not? It'd be nice to see. I'm sure we covered that pretty carefully, didn't we?
we don't.
We don't have the order to do this.
But
It will reflect what is already in the staff notes.
Okay, let's take a look.
I mean, normally for redactions, for every redaction, you have to have a reason. But if we're having 7,000, over 7,000 documents, and a lot of the reasons are the same.
Right. I
Is
mean,
it-
Let me just read something from our notes. Time to review records, et cetera, et cetera. Acting Chair Wolf stated that if these records are in the possession of the city, they are public unless Ms. Powers can provide a citation of law that they are not disclosable. Acting Chair Wolf requests that the FAM SF provide a copy of the contract or MOU with the Corporation of Foundation of the Fine Arts Museums and a log of the public records already provided. So that ball is in your court from my reading of this.
The ball's to do what, sir?
So Acting Chair Wolf stated that the records are in possession of the city. They are public unless you can provide a citation of law. And I understand, and you are going to send questions to the city attorney regarding what does and does not apply to COFAM, and that you're waiting for that legal opinion. Has there been anything on that front?
Well, we pulled the emails of city employees, so we're going into it first, knowing that they're city, is this a city employee, and then going through whether or not it's a record, and then if there's something to be redacted or if there's a reason to be withheld.
Okay, because Mr. Smith states correctly that you have to have certain legal reasons for those redactions. You can't just provide a blanket statement for, 5,000 emails and say these are all redacted because.
Well, we provided him the particular codes for why we redacted it when I sent him the thumb drive. I sent him an email that enumerated the different codes, citing them for privacy, citing them under the different California codes. This was vetted with our city attorney. I don't know how much more.
Yeah, let's take a look at that. Okay. Mr. Smith, could you approach? Thank you, Ms. Powers.
May I respectfully ask that we step back for one moment so I follow this, please?
Actually, I'm gonna follow on with my line of questioning, and then we can go back to where you want to go to. But basically,
What are we talking about?
we are talking about the redactions. Now, you said you probably haven't. You've received it on Sunday, so you may not have been able to look at the documents and see.
No, but I can tell you that the reasons that were given are not specific.
Do you have an example of a redacted document in front of you?
Excuse me. The reasons are just two general paragraphs, and they're wrong. But beyond that, the redactions actually don't conform even to the general statutes. No specific redaction reason has been given in each case.
Can you show
Yes,
us?
and I can show you, please, some reactions that I truly have no understanding of by any legal standard at all. For example,
Could you put them on the projector for us?
I will as soon as I
Thank you.
find them here. Sorry, I'm set up for a slightly different order. All right.
And I appreciate that you haven't had a chance to review all these, but just to give us an idea of what you're getting.
I understand what you want, and I'm going to give it to you as best I can.
All right.
All right. For example, it is basic law that city salaries are public. You can find them online in a million places, but hours worked and salaries are public. They've given me this. The left-hand column takes out the employees' names. That's wrong, and there's no question it's wrong. Next. There's an incoming loan agreement, so it's a contract between this museum and somebody. It's a public document, there's no question. So, what have they done? They have taken out this lender, Wada al-Hajiri, or I'm sorry, I don't know the pronunciation, all of the information. That's wrong. It needs to be there. And a cursory glance at the internet shows where Al-Jahiri is in Qatar, in the United Arab Emirates or the Gulf. I'm sorry, I'm not up on the geography. Those are clearly wrong. Then there's this one, which talks about COFAM documents not releasable to the public. I'm sorry, I'm out of order. That's not about redaction. It's about what they're giving me. Then there's this. I mean, these are so basic
Okay.
that they don't require explanation. Here's I guess a painting or some work of art, and at the top, if I can get it there, it says, "Hi, Karen, so-and-so would like an indication, blah, blah." So-and-so's name is taken out. There's no basis possible for that.
Okay.
And then,
Mr. Smith, let me stop you right there. Those are all good examples. I'm going to ask them to respond to that. So if you
Okay.
can just step back a second. Ms.
All
Powers,
right.
if you could approach. So we just saw three pretty clear examples that were outside of the reasons that you cited for your redactions. Could you talk to these?
Well, the one with the names of the employees, and I'm not saying they're all perfect, so we can go back. I mean, if that one, he needs the names of all those city employees. In the beginning when, you're starting and there's 7,000, your redactions maybe.
Let me ask you, who's redacting? Which person?
Myself has worked on it, and we have a contractor. We have someone who's working.
Okay. Do you understand the rules of redaction and what
Yes.
you can and can't?
Yes.
Okay. Because it appears you don't, from what I'm seeing here. But anyway, carry on.
Well, I'd like to also point out those are 3 examples out of 7,000. So,
He's just looked at. I mean, I don't think he's looked at all the materials. So,
well, the one I think with Ms. Brewer, I think that we were trying to also protect the privacy of people that were maybe prospective and not definitive. And we've told Mr. Smith when we provided him the documents, if he has a question, he can follow up with us. The way they are indexed on the thumb drive, they're very easily labeled by file, and he can email us and say, "Can you please tell me why you redacted such and such for," let's say that's K Brewer, TAC, whatever date, TAC 7, and we'll look at it. But I think to the previous point that if we need to, on every single one, write the basis of redaction, it's going to significantly slow it down. I mean, there's no doubt about it.
yes, but now that you've demonstrated that you're redacting incorrectly, then maybe you'll need to do that. So, I mean, you need to redact to the letter of the law and not just what you think should be redacted. That's the point I'm trying to make. And again, part of what we're trying to do here is set a schedule of deliveries, and maybe a second document where Mr. Smith is coming back and saying, okay, these I've got these, they still appear like they should not be redacted, and that's going to get thrown back onto your workload. But we'd rather avoid that in the first place, to only redact what you should be redacting. There is an expectation of being in the public domain when a lot of these documents get submitted to a public entity such as yourselves. Mm-hmm. So I appreciate you're trying to be cautious, but at the same time, you have an order of determination against you. You need to follow the law here. So.
Yep. And if he wants to give me the copies of those 3, I can take them back and see if I can find.
I think rather than that, you're probably going to get a list from him more than just that. So we'll use that as a working document as well. And, if Mr. Smith and yourself can kind of keep that log up to date with our clerk so we can see,
Okay,
where
but
that is as well.
And, depending on how many that he provides, I'm just going to say it may impact the 5,000 by 2
That's
weeks.
fine. That's fine. So
It may be part of that number.
right, but if you get your redaction policies down tighter, they should be less. That's the point I'm trying to make.
Fair enough?
Yeah. Okay. So,
So I mean, it seems like this process has started. There's some fine tuning. We're going to try and get a schedule and a formatting on here that we can keep track of.
Right, and I think we should tentatively schedule it sometime next month at one committee meeting. I know this committee doesn't meet every month.
Right.
But some committee should have this
Just so we can see what progress has been
to
made.
continue along with this.
Okay.
And Mr. Smith, with the amount of information there is, this could take a while to get you all this
Well,
information.
it's like discovering law and usual document dump in journalism. How many of the documents are just absurdly irrelevant to my purposes? I mean, there are thousands of them that are completely trivial. I've gotten that part. But can I step back for a second now that we've addressed?
Before you do that, I'm going to say one more thing. You mentioned that your IT department developed a new algorithm. Please share that with Mr. Smith, if it's a shirt string or whatever it is, because that might really inform him as to whether he's getting what he wants. I think that would be helpful. You can answer that later. Okay, Mr. Smith, go back to where you wanted to start.
I don't mean at all to engage in a colloquy here, but I'd be, with respect, to ask you to put yourself in my circumstances. It's my current intention to write about this, of course. I'm not doing this for no purpose. And what I've already found out is quite beguiling, as I think the committee has seen. But this has been, folks, what, a year and a half now? So the longer we allow the museum, you'll forgive my plain speaking, to drag this on, their purpose is served. It's not impossible to do this. It's only a matter, as Mr. Kanata said at the last meeting, of how many hands are doing this. And the second thing is, how many hands with what level of expertise? The museum's representative has corrected me at the last meeting when I said she wasn't trained in this. She said she was. And they have two attorneys on this, one from the city attorney's office and one from a law firm in the city. Two. They can't be getting this so drastically wrong. And what I've shown you means that there's a fundamental misunderstanding of what public information and redaction parameters are. One, there's a time. Two, what am I getting? If they're just giving me exchange between Silo 2 and Silo 1, that's not what I should be getting and not what I asked for. And I really am trying to avoid coming back and asking you folks yet again for your kind intervention. Thirdly, I was trying to show you that in terms of the redaction, this is how very wrong they are. I can't believe it. This is what I was sent. It doesn't matter as to which paper or matter or whatever. They cite two authorities which are completely inapposite and stand for the reverse proposition. If they would get some guidance.
I'm sorry, where is that? Is that an email from them? Can you show us the header on that?
I'm responding to Ms. Powers, citing what she has sent me. And it says that I say she cited section 6250, which says the exact reverse. It says access is paramount and fundamental, not that things should be withheld. And she cited the Sunshine Act of all things, which of course says that public has the right to an open process, not the reverse. These things stand for completely the reverse of what the museums have said. Finally, in terms of reaction, I just don't want us to be caught up in 1,000 different redaction problems if we can possibly avoid it, folks. It's not my burden to list all the things they've gotten wrong. I could do that practically for every redaction they've made. I can show you more of them if you like. I won't burden you. But if they are doing it wrong, then the list is going to be very long. If they would apply the law with the two attorneys they have, then we wouldn't have this problem. And finally, I don't know how this base of documents has shrunk from 70,000 to 32,000. How did that happen? In any event, now we're out to mid-July to have even this reduced base dealt with. Mid-July. So 3 more months. I'm only, with great respect, asking for some help here. I mean, I have the feeling they're going to come back and say, based on the whole experience of the case, or cases, that we're not able to keep up, that we haven't got enough people, that the redaction is taking more time, and so on. At some point, they must live up to their obligations. They can't be taking out something that a lender or whatever he or she was in Qatar is in Qatar. What's the basis for hiding that? I've said my piece. I really need us to focus on getting the stuff out. It's not my burden to do so, please.
Thank you. Do we have a date we can get this before us again? That might be the good thing to.
To what purpose, though? That's
Well, just as, I think, I think we've set a schedule. We have some deliverables. We have numbers. We've addressed the redaction. So when they meet in front of us, let's say in a month, whether it's, it's a committee that the three of us should be at, if not, maybe one of the complaint committees.
Are you suggesting the compliance and amendments meet next month instead of EOTC?
No.
No.
I'm just saying that we can have this come up at one of the other, maybe complaint committee. We can hear it there, just to keep on track. I mean, what we'd like to happen is we're going to set up a schedule every 2 weeks. They're going to copy you. Ms. Powers is going to copy you as to what's being sent to Mr. Smith. Mr. Smith is going to keep a log of material he feels that's been redacted incorrectly to be resubmitted to him, and we're going to watch that in the background. But I want to set another meeting date a month, 30 days from now, which will go through 2 deliverables to see where they are. And yes, we can take stronger measures at that point if we need to, Mr. Smith. So we're trying to do that. We're trying to do it. We're trying to make it reasonable. And I think that's probably the best course of action. So what do we have on the calendar that meets next month?
Next month, I believe, is EOTC and complaints. So do one of you want to come to the complaint committee meeting
Sure.
next month?
Yeah.
yeah.
And, all right.
Yeah, we can do that.
Okay.
What date is it?
Oh,
There we go. Yeah.
And but we want to schedule it no later than the next committee meeting.
Right. But regardless, the deliverable schedule is every 2 weeks. So
Yeah.
and we want to see updates on that. Sure.
or just
they
a
call the
committee.
chair.
Yeah.
Call the chair, most likely next month's complaints committee, is what I would word that as.
Just so I'm clear about my burden, which I don't think I should have, but in any event, my burden is only to say email dated such and such date from to or whatever, not redactable. And then it's up to them to fix it or whatever they're going to do.
That's fine, yeah. Keep a log of that for us and copy the clerk on that.
Sorry?
Yeah, keep a log of those instances and send it to our clerk, let's say every 2 weeks, just to say, of the 3,000 they gave me, I had to send 100 back. We'd like to know that.
Should you, I don't know the answer, I'm not presuming, but shouldn't the city, shouldn't the task force be getting a copy on thumb drive or anyway, in any fashion, of what they're sending so that it's available to other people?
We've asked them to send you and us every 2 weeks the amount of emails and documents that you've sent.
But I mean the documents themselves. No? Are they available to people who aren't involved in this matter? I'm trying to get...
I see. They're in the public domain, is what you're saying.
Yes, I'm trying to push them in the public domain.
Yeah. 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 Yeah, talk in the mic.
Can you say what you just said in the
Yeah.
Sorry.
So, Madam Clerk, how would you like to handle that?
She can send me a disk or a thumb drive with everything that she's forwarding to Mr. Smith. All she has to do is make another thumb drive or put it on a disk.
Okay.
And then I can keep it in the record so that if we have to look at this stuff,
Okay.
it's made available.
And could we go back and capture the ones just sent?
I think we can do that. Yeah.
Thank you so much.
Yes.
So the burden, Ms. Powers, if you'd approach, please, just so that we're clear on the record. So I think you've followed what we're doing there. So if you could send the original thumb drive that you sent to Mr. Smith to our clerk. We're also asking you to create just an Excel spreadsheet saying, we sent this, the next deliverable, June 1st we sent this, June 15th we sent this, and just send us that every 2 weeks along with the thumb drive. That'd be great.
The next one is what, May?
May 1st, May 1st, May 15th.
First is Sunshine Task Force meeting.
No, but that's not, that's just when
this
they
is
have
her
to send the
calendar.
next data dump.
This is the deliverables calendar. Yeah. So these are going to come to you, Cheryl, from Ms. Powers, and then please copy the chair so you can see the progress.
Okay, so do we need any motions, or it's just,
Continue and to schedule at the next available hearing and
Okay.
committee meeting
All right. So
Okay.
motion to continue with the stipulations listed and to continue to the call of the chair.
Second.
any public comment on the motion? Seeing none, let's have a vote. Since,
Can I just ask one question before? I just, my one concern about even going beyond, we'll stick, in our minds, looking at what the complaint is in the file and all the things that have been submitted as to where we're getting the COFAM FAMSF is from his specific complaints. And so when he comes in here and he's like, I don't know where they're coming up with that, it's from the file. So he has made
Talking
other
about the original request.
yes,
Okay.
and so he's made other requests that I think he thinks he can just throw into this
No,
basket.
you can stick to the original request.
Okay.
And then as those requests don't get answered in time, hopefully they will, he can bring it back before us, and we'll go through this whole process for those as well. But your mandate is the original request. That's correct. And as one other note, please either have your IT person that came up with this algorithm talk to Mr. Smith directly, or give him the new search term, which resulted in 32,000 versus 70,000.
Well, I can speak to that right now.
Okay. Might as well get it on the record.
I have the piece of paper right.
But if you have a copy of that, that would,
Well, it's something that they wrote for me, but I can.
okay, because that will help inform Mr. Smith as to, what he's getting and the nature of the documents he can expect.
Basically, the 70,000 originally was, like I said, it was a count of all emails to and from. If you're a city employee, so it could be from them to like their mother. It was like anybody.
Okay.
Then I came back and I explained to them, the time basis is January 1st, 2018 to March 3rd, 2018. And all of our conversations over all of the committee meetings have been totally hinging on the idea that everything is at famsf.org. And the request is COFAM to FAMSF. So we then extracted emails based on the criteria of the sender and the recipient having a famsf.org address. And that became an extraction of 230,000 emails. And then they went a step further and entered into it. So they were able to create, and this took a long time, which ate into the beginning, but they were able to create sort of like an equation or a way that on one side of the equation has to be a COFAM employee, and I gave them a spreadsheet of all the COFAM employees during that time period, and a FAMSF employee. And during that time frame, with those things to and from, it made it down to about 14,000 something emails, and with those emails, about another 17,000 attachments. So it isn't necessarily 32,000 emails, it's a total of about 32,000 documents.
Emails and attachments.
Yes.
Okay. Okay, good.
That's how they did it.
Okay. All right. Thank you for that. All right.
okay.
Cool.
Mr. Smith, one last thing, come on up, I know.
I want to be clear.
Thank you, Ms. Powers.
When I put in the original request, which is what I understand you've just told the museums to respond to, I had no notion of Silo 1, Silo 2, Silo 3, COFAM, FM, any of this stuff. The requests were directed to the museums. So if they are now somehow construing that as to mean only communications between COFAM and FM, whatever, SIWO 1 and SIWO 2, that's wrong. If we're going back to the original request, let's stick to the original request, please.
Well, if that's what the original request was, which I believe it is, and I'm going back to look at that, then you need to make the second and third and fourth requests to get the other. Now that you know what the lay of the land is, go ahead and file those IDRs. They have 10 days to respond to them. If they fall behind, that then comes before us as another item, and then we'll go through this whole process again if we have to. But hopefully they're catching up as to how to respond to your requests. But you will have to do the extra legwork because the mandate of this is purely what the
original request.
Yes.
I just want to make certain that we're talking about the very original request, because that didn't talk about what I just heard. It talked about the museums and not the internal constituent parts of the museums. I wasn't even aware of them. So I just want to be clear that that's my understanding.
That's a fair point. I have to look at the original.
If we're being guided by the original requests, then this...
The order determination, we should actually have that in front of us, do we not? It's not part of the package
No.
or the notes?
But
Is it not in the original? If you could put that on the viewer for us, that'd be great. And this is what the order determination was made on, right? This original request? The actual IDR, the actual request is what I want to see. What began all this.
the actual request itself is about 2.5 pages because he included 5 subject matters
That's right.
that all had to be separated.
Right. Okay.
Really articulated. If you look at page 186, in one of my inputs to one of our previous committee hearings, I stated, and I can find it in here where it's even in his own writing. I don't understand. Mr. Jones even reiterated it to Mr. Smith on page 145. I don't know why this is happening. He doesn't remember that he's saying it's not all correspondence and documents relating in any fashion to and from Corporation of the Fine Arts Museums and the Fine Arts Museums of San Francisco. That is the request.
So is that the request, Mr. Smith? That
The original request.
right? That doesn't mention silos. That's going.
I didn't
Okay.
know about silos.
Okay, so that's
Whatever the original
and that's what it
request,
seems like they did.
was.
One side or the other.
Yeah.
not interpreted
Okay.
by the
So
museums.
I think we're fine right now. We'll go down the road. We've got a motion that needs to be voted on, and hopefully we get you your documents. That
Hopefully.
Thank you.
okay? Can we take the vote, please?
Member Highland?
Aye.
Member Highland, aye. Member Hensy?
Aye.
Member Hensy, aye. Chair Kanata?
Aye.
The motion passes. Motion continue and schedule the next available committee meeting.
Thank you. Okay, next item.
Next, you should call the next 2 items together and make a decision on both of them and do a full task force together.
Okay, that's fine. We can do that. They're both. It's all well. One item's against the management of City Hall, and the other one is against the Sheriff's Department. So do we have representatives from both here? Okay, great. And Mr. Tedeschi is here, right? Okay, so let's call both of those together. And
Shall I read them now?
Please.
go ahead.
Item number 5, file number 18012, hearing on the status of the order of determination. Complaint filed by Denton Tedeschi against Lori Mazzola, City Hall Building Management for violating Administrative Code Section 6713A by failing to allow access to a meeting of a policy body. Item number 6, file number 18028, hearing on the status of the order of determination. Complaint filed by Denton Tedeschi against the Sheriff's Department for violating Administrative Code Section 6713A by failing to allow access to a meeting of a policy body.
Okay, thank you. Mr. Tedeschi, so both of these cases are for compliance to allow Mr. Tedeschi to be able to come into this building with his service dog off leash. Have you been able to do that, sir?
No, I have not. I have. It's almost like telling someone who has been under threat from police to actually go up to a police officer and say, "Hey, here I am. Let's see what you can do." Or can you arrest me, please? Or I'm not going to do that.
So have you?
I think.
Are you saying you haven't tried?
I tried once, and the lady said no. So I just completely, I didn't even.
When was that? Was that after?
This is maybe about a month ago.
So it was after our order determination. That's when I was.
Was it after your order determination? I believe so. Yes.
And are we, through the chair, are we monitoring? Monitoring it for compliance to let him in with his service animal?
Yes, the order of determination was that the ADA code did not specifically say that the dog had to be on leash. It was an either or situation.
Yes.
So the order of determination was made. So Mr. Tedeschi should be able to enter City Hall with his service dog off leash as long as it's under control.
Yeah.
Okay, so
Yes,
who's representing building management?
Okay. And if I may so, add to this, I think it's for them to tell me that, you know what, we have reversed our decision and we welcome you to City Hall with your service animal off leash.
I don't know if that's the case, but you are allowed into this building with the animal off leash under control. Sir.
Good evening, John Gavin, San Francisco Real Estate Division, on behalf of the building management of City Hall. A statement and then some follow-up. After consulting with the City Attorney's Office, our position and policy on this matter has not changed for the reasons outlined in the City Attorney's Office's advice memorandum dated April 13th, 2018. That memorandum is in the task force files, should you wish to refer to it.
Wait a minute. That was back in 2018. This case was heard and decided after that.
Right, and after consulting with the City Attorney's Office, they stand by the same policy. And in consultation with the City Attorney's Office, your task force ruling is to be considered a statement of opinion only.
Okay. Can we hear from the Sheriff's Department? Please. Where does the Sheriff's Department stand on this issue?
Hi, I'm Captain William Kelleher, the Field Operations Division of the San Francisco Sheriff's Office. So again, we are operating under the same memorandum from the city attorney. What we have determined was that a training bulletin will be put out where at the question will be if there are two exemptions to this instance. There are only two exceptions to the rule where the service animal will be off leash. First, service animal need not be leashed, harnessed, or tethered if the handler is unable because of a disability to use a harness, leash, or other tether. Second, the service animal need not be leashed, harnessed, or tethered if the use of the harness, leash, or other tether would interfere with the service animal's safe, effective performance, work, or tasks. A public entity may ask what work or task the animal has been trained to perform if the nature of that work or task is not already obvious. So the training would be that we would ask that question and then
and you're absolutely right. You can ask that question, but the answer to that question only comes from the person who has the service animal.
Right.
It's not the Sheriff's Department or building management's prerogative to ask, well, what service does your animal provide? And then when the person tells you, well, he can do that on leash.
That was not my contention.
Okay. All right.
So that was the training bulletin. We would do that. Once we add an answer, then the follow-up to that is we would let that person in. once they provided the answer, when that service animal is no longer providing that service, at that point they would be tethered or harnessed.
So here's a hypothetical. I'm going to answer that question for you. My service animal is trained to provide nonviolent protection in the case that I need it. How would you then handle that?
Okay, well, if you have a service animal that is providing you a service, right? Then if it's not providing you that service, then it has to be harnessed, right? So if your contention is that it's always providing you that service,
yes, the training it's received is to provide me that service should I need it. That moment can come at any time. That's not something medically I can control. That's my
then we would follow the ADA directions. So your animal has to be under control, cannot be on the furniture, cannot be aggressive, it cannot be, it has to be house trained. All the directives that are posted on our entranceways in conjunction with the mayor's office on disability.
Okay.
And then if your animal is disruptive at that time and you cannot secure your animal, then we will take appropriate action.
Okay. So you've answered the first part of it as yes. So those are all the things that this gentleman has said to gain access. So the next time he comes and says exactly what I just said, you're going to let him have access, and then you can make a judgment call if his dog is not under his voice control, if it's causing a menace to others, if it's defecating, and then you have that right to request him to put on a leash. Are we on the same page?
That is the direction that we're going, yes. And the training will be put out with our training bulletin to ask those questions.
Okay. So from what I heard, your training bulletin is you're reinventing the wheel. The wheel has already been invented by the ADA laws, which trumps everything. It's out there. And that example I gave you is within that. Your example seems to suggest that there has to be a physical reason why.
And that was not my contention. I didn't say that.
That's kind of how your training document reads. And that's what we're trying to point out to you, that the previous documents you had posted around City Hall are incorrect. They're not in compliance with ADA. That statement you're about to put out is not quite better, but still not quite. Read it again.
That's not my statement. That's the city attorney's statement.
Okay. You said that you're going to provide training to your staff based on that statement you read out.
Right. That's correct.
Okay. That statement is not within ADA.
Okay. Well, we worked with again, we're following the directions that it is compliant with ADA, the deputy city attorney.
Okay.
So until they make a different judgment, then we will do that, and that will be.
There's a lot of passing the buck here, and I realize you guys are working for several different masters, and you're carrying out policy that they give you. But as officers of the law, you also have to know the law, and that's what I'm imploring you to acknowledge. I mean,
we do know the law, and we are following it. And what is posted at our entranceway, there is a caveat on the bottom unless an exception applies.
Okay.
So it is correct.
Because the previous document you had posted is incorrect.
Which one?
Where it used to say, and must be on a leash. There's not an and in ADA, it's and or. And
okay.
You guys skipped that. So
well, there's an exception, so that would be the exception.
Well, that's a different way of getting to it. But so I just want to restate that in my example, if I told you that my dog is providing nonviolent protection for a condition that I have, which may present itself at any time, not under my control, you would give me access to City Hall with my dog unleashed under my voice command.
Once again, yes.
Okay.
Thank you.
And so what I'm hearing, though, is that differs from what building management has said. So, sir, can you come up here from building management, please? Because, so how does your stance differ from the sheriff's? It sounds like the sheriff's department is training their people to know which questions to ask and to allow a person with a service animal under their voice control to come into this building with that service animal not tethered or on a leash.
That's what I heard today.
Okay, so how does building management agree or disagree or differ from that stance? Because what I heard you say before was you're not going to let him in.
Perhaps you can just reread what the officer just read, that that he claims that you guys gave him to read? Or who?
Pardon me?
Perhaps approach again. Then who gave you that directive for your training? Let's get back to that. So
This is not from building management.
Okay.
This is from the city attorney, Deputy City Attorney Matthew Lee,
Matthew Lee. Okay.
dated April 13th, 2018.
Okay, that's that original document that predates this whole case.
That's right.
Okay, and if you could reread that for us, especially read the part where you're talking about the new training.
There's nothing on this document without the new training.
Okay,
what I said is we'll be putting out a training bulletin that incorporates the issues from this memorandum.
Okay, so this memorandum is, well, it's because of this case, it's kind of out of date, and it's not in compliance with ADA. But tell me again what the words of your new training directive. That's what I'm trying to get to.
Once again, the training directive will be in compliance with this directive, as that is the most current thing we have, and we take direction from the city attorney regarding such matters in consultation with the sheriff's legal, Mark Nico, and that's where we're going with this. Again, we will ask the questions that are put forward in this document, which are. I'll have to pull it up here.
Okay.
I'll have to pull it up here.
While you're pulling that up, if you were following this document, and it sounds like Mr. Tedeschi should have been let in the building, why wasn't he? Again, no respondent in any of these cases have said that Mr. Tedeschi's dog was not manageable by him. So why wasn't he allowed in the building?
Well, first of all, I don't know exactly which case you're talking about, but a animal control expert was on scene, had made a determination that the dog was showing signs of aggression. So that is.
I'm sorry, I'm going to interrupt you. That's the first we've heard of that, and we've heard this many times.
Okay,
I'm going to throw that one right out the door. What we heard was that someone at the front desk called someone in this, building management who read them this and basically threw it back to you guys. You're the point. You're on the front lines. You have to make that subjective call. So again, we're asking you, what about Mr. Tedeschi's previous request to come in has not allowed him to come in? I mean,
well, we were following the directive of the rules at the time before this case came forward, right?
Yes.
So the directive of the building management, and we act as the agent of the building management.
Right. So you're on the front lines. You have to make that subjective call. Does he fall in these exceptions? Based on everything we've heard and based on those exceptions that Matthew Lee wrote, he does fall into those exceptions. So again, what was it at the time that in your eyes disallowed him from being one of those two exceptions?
Well, we keep going back to this. We're talking about going forward.
Okay.
So I don't want to speak on issues that I was not present for,
Fair
nor
enough.
have I been well versed for. What I'm versed in is what we're going to do moving forward.
Okay.
If you want to revisit old issues, then that's a different matter.
Okay. So, and I like that. Let's keep this moving forward. If Mr. Tedeschi comes to his next meeting here, and he has a lot of cases here at City Hall, and presents himself. He has a history with your staff, so I would almost like for you to be there because you're at least you're up to date and looking forward, or someone that you can delegate to that would say, this is Mr. Tedeschi, here's some history, we're going to ask you the questions, is your dog under control, please come in, and that's what we'd like to see. So how can we get there?
Okay, well, number one, I won't be there. I'm the captain assigned to Field Operations Division, so I do not work in this building, and I have a unit manager, and I have staff assigned here. The training will be provided to the staff here, and the training will be provided to the unit manager.
Okay. So if we continue this case, would it be unreasonable to ask that person who actually works the building to come before us at the next meeting? Because we're going to keep continuing this until we hear that this is being complied.
I'm sure schedule the meeting, and if that person is available, then they will be here.
Or at least someone on that team.
But we don't want to wait until that meeting to have Mr. Tedeschi be able to access the building. So this is, this has been going on for a long time. ADA is really specific on this. So it's, and the ruling of the full Sunshine Ordinance Task Force is not an opinion. This is a ruling.
Hold on. Wait, I'm sorry.
I mean,
Talk to the
this
mic
is
for
a
second.
ruling, so unless the next time Mr. Tedeschi comes to this building for a meeting, if he is not let in with his service animal, there has to be specific reasons where somebody can come up here and say a service animal was being aggressive or something like that, because ADA is incredibly specific on this. The man is allowed into this building with his service animal off leash to go to public meetings.
So I'm not an expert on ADA law. I don't purport to be.
But you're building management, and it's up to the
we're listening
building
to the
to let
city
him in.
attorney's opinion on the matter.
And the city's attorney's opinion, what the sheriff had up there, is an either-or case. The dog's allowed in here off leash.
The city's attorney's opinion agrees with what we're saying. If he presents himself under the correct exceptions, he should be granted access. So we're putting it to you the next time he does that and presents himself and lists those exceptions, you can ask your questions. He should be able to come in.
And going back to your city attorney's opinion on the matter, it talked about it's, as you mentioned, the front lines. It is the discretion of those on the front lines.
Absolutely.
They have to make that choice.
And they have to have the training to ask the correct questions.
And then it's up to them.
Right.
For the safety of everybody.
That's
to
correct.
Make that choice.
That's correct. So we're going to probably continue this, and he's going to present himself. If he's not allowed access, then we want some very specific details as to why that person made that determination. So this is not over, basically.
Okay, so Mr. Tedeschi, why don't you have the last word here before we...
May I add just, Mr. Gavin actually called Superior Court. The task force asked him to reach out to Superior Court. He actually did reach out to Superior Court. And guess what happened? I had a request for 850 Bryant to have the same accommodation that I had at 400 McAllister. All of a sudden, they started slowing down. They delayed the response. Then the gentleman who had helped me, who I have much respect for, told me point blank. He said, "We got a call from Mr. Gavin." He actually had a talk with him, and basically from that conversation, we will allow you to have your service animal off leash in the courthouse, but before you go to the courthouse, in order for you to get from the steps of the courthouse inside security to past the sheriff's officers, you will have to call us, and then we'll have somebody there, come. So basically, because I won the determination, Mr. Gavin took it upon himself to actually contact the Superior Court ADA coordinator at 850 Bryant, specifically because that building is owned by the city. That's unacceptable. Unacceptable. So basically, my determination from here has basically regressed my ADA accommodation request.
Okay.
Can you believe that?
Mr. Gavin, would you like to answer that? Yeah, you have a chance to respond. Go ahead.
The person I spoke with was the state courts, and he made his own determination based on his own building. So that's. I just had a conversation of, as per our discussion,
right.
You suggested that I contact him, so I did. So I listened to his thought process on the matter.
Okay. I mean, to me, this is just mind-boggling because ADA covers the entire city, the whole infrastructure here. So what are we going to do with this? We're going to continue it to the call of the chair and...
Yeah,
I think so.
And just keep it open-ended until we have proof that Mr. Tedeschi is allowed access in and out?
That would be one thing we could do. We could also send it back to the full task force for. But I think we have to. I think we have to have either he is or he's not allowed in. And we have to have some evidence to be able to move.
Right. I don't think we send this back to the full task force.
Not yet.
No.
Okay.
But a possible thing to do is send it back for Section 34 violation.
Once if there's proof.
Yeah.
Right. If
Right.
Yeah. Okay.
May I ask when that training will be provided to staff in City Hall?
Good question.
Yes. So both the sheriff and building management. When is this for the sheriff? When is your training going to be provided?
The training, we'll probably put it out this Friday, and the training is provided in what we call muster roll call. So it will be put out, and it will be for the week. So we'll put it out Friday, and it begins Monday, and they go over it every day for that week.
Okay, so if Mr. Tedeschi came in on Thursday, how do we, I mean,
Or when would all the staff know so that he can approach?
Right.
Have a
But
reasonable chance?
training, we're a large organization, so we have training parameters. So we can't do instantaneous training. We have people that would be off
Right.
duty, people that aren't here. That's why it's over the course of a week.
So, for timeline's sake, when would everybody know? When would everyone have gotten this training?
So if it started on Monday, this coming Monday, I don't have the date in front of me. It would end on a Friday.
so it'd be the 22nd.
So it'd be 5
to the-
continuous days of training
So-
on the training bulletin.
Basically, by the end of the business week, everyone should have gotten.
Next week, the
This
next
Next
business
week.
week, yeah.
Starting Monday.
Okay.
Yeah.
And does building management get trained also? Mr. Gavin, so is it just the sheriff's department out front? Or how does building management get involved again? Bring me into this again.
Okay, well, we take direction from building management. We are an agent of the building management, but we are a law enforcement agency.
Right.
So we are not their employees. We contract.
Right, but building management is not down on the front lines. It's the sheriff's department.
We are the ones allowing
Okay.
access, and if they contact us that the dog is being disruptive, violating building rules, not in compliance, and Mr. Tedeschi refuses to harness or leash the dog, and we observe that, then he'll be asked to leave.
All right, thank you.
And what is the name of your on-site manager? Your person?
Sergeant
Unit
Davis.
manager.
Davis.
Sergeant Davis.
All right.
Okay, so do we have any type of motion?
So moved, and I might recommend that we request that Sergeant Davis appear before us if available, as he is the he or she is the building.
Right,
Yeah.
but when? That's the thing. I mean, we only meet every other month, so.
Maybe the same time we have Mr. Smith before us next month. Tack it on to the complaints committee. It's going to be a long complaints committee, but I mean, this should stay timely, yeah, because he's saying all the training should be provided by the 26th, which means 29th onwards. Mr. Tedeschi should be able to enter, explain everything very carefully, and you know, if we have a thumbs up, then we don't need the meeting. But it wouldn't hurt to continue to call the chair, like we did, and perhaps have
Okay.
it scheduled. Just have it there, ready to.
That sounds fine.
Yeah.
So, motion to continue made by Member Hines, and I'll second with the changes that we mentioned.
Okay, any
Thank
public
you.
comment on the motion? Seeing none, let's have the roll call. And this is for both of the 18012 and 18028.
Member Highland?
Aye.
Member Highland, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair Kanata?
Aye.
Motion passes.
Okay, let's have our next case.
Next matter, file number 18010, complaint filed by Denta Tedeschi against the Office of the City Attorney for allegedly violating Administrative Code, Chapter 67, regarding violation to the rights of to privacy.
Okay, so this hearing is for two things: to determine if we have jurisdiction, and if we do, to
I
find
believe
facts.
you've already found jurisdiction at a previous meeting.
On this one?
Yes, it's an older complaint.
Oh,
Plus, it's not regarding public records, so there's no determination of there's no finding for. Oh yes, you are correct.
Yeah,
Jurisdiction, but there's no public records involved.
right, exactly, yeah. So the city, Office of City Attorney's, a city government office, so I believe we have jurisdiction.
So, second.
Okay, so,
I'll move, actually.
and can we take that by acclamation, the jurisdiction?
Take public comment on that.
We have public comment on the motion for jurisdiction. Seeing none. Okay, so
I think.
you're part of the
But it's a
you're
motion
part of
for-
the proceeding.
But I think he's allowed to do that.
Oh, okay, sure. Okay.
This is regarding jurisdiction only.
Yes. Go ahead. So let the gentleman go first, since he was in line first. Go ahead. All right.
Thank you, task force members. John Cote, I'm the communications director for the city attorney's office. Pleasure to see you again. I just wanted to point you to our March 14th response from our office to this matter, and respectfully ask that you dismiss this complaint for lack of jurisdiction, consistent with the finding of this body in complaint number 17057, also by Mr. Tedeschi, also involving alleged violations of personal privacy. And this body on October 4th of 2017 found that it did not have jurisdiction on subject matters of personal privacy. So for that reason, I would ask that you dismiss this on jurisdictional grounds, and then I'm happy to discuss the merit issues later when we get to that point.
Well, but if we don't have jurisdiction, we don't have any merit. We don't hear the merits. So,
Agreed. Right.
Step back here. Yeah.
Mr. Tedeschi.
Yes. First of all, this file number 18010. This file, I did not change that number. It was originally 17057. Under my understanding, when I talked to the administrator, Mr. Young, was that this was a reconsideration for that same matter. I don't know why it was changed to 18010, and then also not including George Cothran as the complainant. It only just says city attorney. I never authorized that. I never thought that was going to change. Number two, I thought that the third item for today's meeting was going to be actually the one for the SFMTA, file number 18011. That was the call that I got from Ms. Leger last 2 weeks ago regarding what was going to be heard today. This file number 18010, for it to be shown in all of a sudden on today's agenda was a surprise to me. But if I'm willing to go on this one as well, but what happened to the website with the SFMTA issue? And I've been waiting for a long time for that.
It's my understanding that that item is already before the full task force and awaiting hearing for the full task force.
Okay, so then this particular item, I was under the understanding from Mr. Young that it would not be included until I actually provided more information to the Sunshine Task Force on why I think that it should be reconsidered. I never did that, and it automatically just came upon.
So let me get my head straight around.
Okay,
so,
sorry.
So is this a reconsideration, Victor?
I thought it was.
It's not my understanding. It's not. I don't recall that.
Okay.
There was never a request for reconsideration. I believe there was a case in this item where he was not able to get into the building, and we filed the matter. And when that occurred, he requested that it be reopened, and we reopened it on his behalf.
But that's not this one. That's a different one.
That is, I believe this might be the one where we reopened it.
Yeah.
I can't tell for sure.
Well, from the notes I have, 18010 is against the Office of the City Attorney for violation of privacy for delivery of personal information. So it has nothing to do with getting into the building.
Yeah.
So
I believe it's not about getting into the building. He wasn't able to come to the meeting.
Because of,
And then we filed it because no one showed up. And then we reopened it at his request.
And then when it was reopened, I thought it was going to be reopened under that original number, the 17057.
So you're saying you're not ready for this?
I I am ready, but I mean, I don't want it to be because you don't have the information in front of you. I don't want that to be held against me, because I definitely do have the information. I can give you the information orally why I definitely think that you should have jurisdiction and that I have a valid complaint.
Okay, thank you. Okay. That was the public comment. Let us do some discussion. So, I mean, the Office of the City Attorney, we definitely have jurisdiction over the body. So is it, Mr. Desi, not yet, is it, can we move on with this because we have jurisdiction over the body, and yet we may not be able to provide any redress on the privacy issue? So that's one question, and the reason I'm asking is because the normal function of what we're doing now is to find jurisdiction and gather facts to send it up to the full task force.
Right.
Right? So how do we proceed with this? Because I would think if both parties are ready and we have jurisdiction, we can just get the facts. As long as all the facts are here, then we just send it up to the full task force, and the full task force will make a determination whether the facts can be redressed by the Sunshine Ordinance.
Do we have the materials in the package today?
What I pulled out of it was that it's basically violating my right to privacy due to non-disclosure of persons who have filed complaints against city agencies, which I'm covered under. Sunshine Task Force has jurisdiction over this law, and it's basically the SFMTA dropped off an unsealed folder at the complainant's residence that contained a copy of their decision that barred the complainant from riding SFMTA public transit for 5 years. And Mr. Tedeschi is claiming that's a violation of privacy.
But we have the materials.
Yeah, that's what I found in the package.
Okay.
Correct.
That was all I had in 18010.
Okay.
So, Mr. Tedeschi, 3 minutes, present your case.
Thank you.
Let's go with this.
Thank you.
Yeah.
Okay, so this issue has everything to do with the deliberative process privilege. This privilege is it was regarding a city agency and their impending decision to revoke my cable car privileges with my service animal, because of my service animal, and that revocation process, what I'm saying is should have been private. It is a public meeting, but that was a closed meeting. It's under the Sunshine Task Force's closed meeting section, and the deliberative process section regarding the part of information that is confidential prior to a agency's final decision. This kind of goes back to what I heard on the podcast regarding your last hearing under RFPs. This has everything to do with the rules of professional conduct. On the notice itself that I got from the SFMTA, it said that this meeting is going to be confidential. This meeting is going to be this meeting is a closed meeting. Actually, I have proof of that. I will definitely submit that part as soon as I can.
What meeting are you referring to?
Yeah.
The SFMTA meeting itself.
With you.
The hearing.
I'm sorry?
The hearing about
Yes.
your rights to use the cable car.
Exactly.
Okay, but just let me,
Yes,
just
sir.
so I'm totally clear.
Yes.
Your complaint is not about the meeting. It's about
The process
the process of
the city attorney's office giving the revocation paperwork to my building manager in an open envelope.
Since it was going to be a closed meeting, why would they not give it to you privately? Is your argument?
Because they wanted to leak to the press. is because that's what happened. It was leaked to the press. This process put me at a disadvantage at the appeal hearing, which happened after. This was in March. The actual appeal hearing happened in March. The revocation notice was given to my building manager on February 7th. I complained about it regarding the privacy issue. I thought that I should at least have privacy safeguards around that. I did not. And later on, I find out that there's actually codes in the law.
Quick question for you:
issue.
If let's say we go down this road, we find jurisdiction, we have an order of determination, we rule in your favor.
Yes.
And we might do all that.
Sure.
How's that going to help you?
This helps. This helps in the whole process of how I'm even being treated with the sheriff's office, with city hall building management. This has everything to do with my service animal. This has everything to do with what I'm saying about the website change. You had a gentleman in front of you guys telling you that the website change was changed on January 6, 2017. Exactly what I'm saying. Yet I still cannot get a definite decision from the Sunshine Task Force regarding that. So I'm going about this every single.
Yeah, the reason I'm asking that is, and I really shouldn't ask that question, but I'm asking it just so that you're aware that you have other avenues to you as far as pro bono.
I do, but I am.
But as far as an exercise, we can take.
I have no money. I'm living in a tent.
I hear you. That's why we said pro bono.
Right. I mean, this is why.
Do you understand what pro
This is
bono
why I am very thankful for you guys. I voiced my concern about this to so many people.
But you know what pro bono stands for?
Yes, I do. I do.
So thank you, sir.
Yes.
Mr. Cote, could you give us 3 minutes of what happened?
Actually, with all due respect, the issue that's before the task force today is not the issue that Mr. Tedeschi discussed. According to the packet you have for this meeting, I'm looking at page 500 of your packet. Actually, it looks like there's a slight mark over it. It appears to be page 500. It indicates that this is about file number 18010, and under 18010, the complaint, it says, please describe alleged violation. It says, violating my right to privacy due to non-disclosure of persons who have filed complaints against city agencies, which I am covered under. Sunshine Task Force has jurisdiction under this law. That's the matter that's on the agenda. The information that Mr. Tedeschi was just providing seems to be complaint number 17057. And 17057, my understanding, was already adjudicated by this body. And this body specifically found back on October 4th of 2017 that it does not have jurisdiction over matters of personal privacy, which is the overarching issue that Mr. Tedeschi was alleging there, and appears to be what he is alleging here in item and complaint 18010. The problem of jurisdiction notwithstanding, there was also no indication that there ever was a public records request by Mr. Tedeschi. There was no information included in the packet about it. He hasn't presented any here today about this alleged violation of his privacy because we didn't disclose persons who have filed complaints against city agencies, which I am covered under, and I'm reading his language there. Okay. So my understanding is that's the matter that's before this committee today, and I would respectfully ask that you dismiss that complaint because of the finding by the task force back in October of 2017 that issues of personal privacy are not subject to the jurisdiction of this body, or separately for the fact that there is no evidence that a public records request was ever filed of our office to that effect.
Okay, thank you.
Mr. Tedeschi, if you could approach.
Yeah, it is.
So this is coming back to me, and I'm afraid I'm going to have to agree with him on 17057. That's where we ended up after a lot of talking in the old, before any of these people.
Yes.
I think Member Canada might have been there. Had that been a public meeting and had it been something to do with agendas, whatever, we could help you. And it really just doesn't fall within our purview. What we would advise you to do, and we can't give you legal opinion, is I think you have other avenues to take that information and help underpin some of the other things you're working on. But again, this looks duplicative to me of the one that we already ruled on.
That's why I asked for a reconsideration based on I found a new area in the law that actually refers to the deliberative process.
But not the sunshine law, not the sunshine ordinance.
It does. It's actually under the CPRA as well, and the CPRA has and sunshine falls under the CPRA as I am, or most of the sunshine law is covered under the CPRA. About 80%. Correct?
Is that in our package? What you're referring to?
And see, this is why I said I did not have the opportunity to actually put it into the package.
I think what should happen is one of two things. You can amend your package and resubmit this, or we can close this out and you can submit a new complaint so that it starts from scratch and it pertains to exactly what you want to say. Because as I go through this package, I read the body of the package, so I was thinking it was the one situation where your information was delivered.
Right.
And then when I read the describe alleged violation, it's totally different. So I agree with Mr. Cote on that.
Yes.
So I would what I think is the best way to handle this is we close this out tonight. 18010 would be done, and then you would submit a new one based on exactly what you want to have heard.
Okay, but I'm just, I'm not sure if it's the I know the administrator for this city, for the Sunshine Task Force, they have their own city attorney's office helping them. I think this is somehow almost, it seems a little bit weird, the fact that all of a sudden this file number shows when I was under the clear understanding that before this ever came up to you guys, I would have to submit paperwork. And since I did not submit any paperwork, I was very surprised to see this show up today. And I also must say that I was definitely under the impression that 18011, the one regarding the SFMTA website, was going to be on today's agenda. And also just for further kind of just notice, in general speaking, on my summaries, on my orders of determination, the summaries are absolutely not right. They completely take it out of context. The summaries in terms of where I'm speaking regarding what I said at that meeting, it's not correct. The January 2nd recording is not available for some reason. The January 2nd recording that has my voice on it before I had to leave with the sheriff's officers, taking my service animal away is not available. It's not even in the summaries. That date never even happened. That's bizarre. I'm just for note. I want it to be there. I don't want. The reason I'm coming here is just to have it on the record. I understand you guys are very limited in terms of what you can do. But if I can't even get the record to reflect what actually happened, then I have issues with it, respectfully.
Okay. Well, I never saw that other case on the agenda for this meeting, and I have not listened to the January 2nd tape, but we can get that.
That was my fault.
Okay. Is it existing anywhere?
The tape does exist, but Mr. Tedeschi's testimony was taken out.
Oh.
It was an error on my part, and I admit that.
Okay.
And it's not even my order of determination. It's almost like that date never even happened.
Thank you, sir.
Yeah.
Okay, so
How do we dispense?
how do we want to handle this?
Just
Victor, do you have any
cautionary.
suggestions?
This is a new complaint. It's not based on any previously filed complaint. It is too late to file for reconsideration of the 2017 file because there is a limit on a request for reconsideration. And there is a problem with filing a new complaint on the exact same issue as we cannot reconsider something previously adjudicated by the task force.
Okay, so for this one, though, the explanation of the issue and the body of the issue are different. So how does that get corrected? Does Mr. Tedeschi have to do something overt?
I'm not understanding the full
In
question.
the form where it says, what's the issue, Mr. Tedeschi refers to city agencies not providing documentation, where the body of it describes the problem as the city's attorney's office delivered personal information about him.
That is why we brought it to the task force. Once we receive a complaint, we have to accept it. We cannot make judgment calls on it. And if we don't get information that's requested, we leave it to the committees to sort through it and make that decision.
I think a simple way of handling this is we refer it to the full task force with the recommendation that we don't find jurisdiction. It dies right there, and then suggest that Mr. Tedeschi refiles a clean item that has all the updated language and package it the way it is, so you don't have any of this old stuff coming back to haunt it. I think that's what I'd recommend. So, because can we kill it right here? No, we have to
It's
set it up.
choice of Mr. Tedeschi. He could withdraw. If he does not withdraw, we would need to go to the full task force to take action.
Okay, so Mr. Tedeschi, would you like to withdraw?
I am unclear about what that exactly means. What? Okay.
So we have to take an action on this.
Okay.
However, if you decide that because of the way it's presently that you don't want to continue with this particular 18010, you can withdraw it and it dies here. You can file a new one with the way you want it to read, with the language that you want.
With all the pertinent information. This one has conflicting information in it.
Yes.
That makes it hard to understand.
And I can't add the information that I thought that I could have had it been.
It's still going to be tainted because it's linked to the old case and all that, and we might even see it as duplicative at that point. So
Okay.
I would recommend doing this as a fresh item.
And how long will it be taken to be heard? Because a lot of my cases are taking extra long time. A lot of the SFMTA website,
Right.
issue
Maybe
seems like it's
maybe our clerk can address that. Our workload is getting better because certain things are falling off it, but
We could pretty much give a good guess of May. Fourth Tuesday in May.
So it would come back.
In May?
Yeah, it would.
Really?
It would come back.
In about a month?
It would come back to this complaints committee to rehear it.
Okay.
And the first question we're going to go through again is a jurisdiction.
Okay.
Like we did, and if it passes that test, then we bump it up to the full task force, which will be in.
Okay.
We cannot say
don't know when.
anything about the full task force,
Okay.
but we guess May, but we can't promise, but it's very likely.
Well,
So
because
we
this
make no
has been an
guarantees.
ongoing thing, and this has
Right.
been can I have your word that it's not going to be delayed?
Only
and
the
delayed
chair of the
and
committee
delayed?
can make that decision, and that chair is not here.
Right.
Yeah. So it would most likely be heard as a fresh item. If let's say you went back and filed something this week,
Yeah.
we'd probably hear it in complaints in May, most likely.
Okay.
And then once we rule on it, then it will go to the full task force, and we don't know when, but
Okay.
maybe within 2-3 months at
Things
worst.
have been moving fairly much
Okay, so
better
I'll do
this
that.
year than they have last year.
That's-
Correct?
I'll
Or
do-
not?
Yes,
Chair
you just
Hyden's
haven't received
advice.
very many.
Right.
Okay, so
Okay.
you can withdraw this as it exists now, start
Okay.
afresh.
Okay.
Or we can kind of.
I'll do that then.
Okay.
Okay.
So 18010 has been withdrawn. Mr. Tedeschi will refile. And do we need motions on that, or is Victor?
No, we do not. I just caution that please make sure it's a new complaint and not referencing anything that's already been filed
Right.
in the past. Because we cannot re-adjudicate items that have already been
Just-
heard by the task force.
Right, so we haven't heard this one, the fact of your private information being delivered.
You did.
We did under 17057.
Yeah.
So is it?
Yeah.
Okay, so
We would not be able to hear that issue again.
So it would
And
have.
I want that issue to be heard because that was it
that
was
heard
first
and
scheduled.
but that was heard and adjudicated.
Yes, but then after that, I found new information, and then I was told that in order to do that, get that information in, and until I put that information in, it won't be heard like it is today. And so all of a sudden, it was just put on
Okay.
the agenda.
Then
today.
another thing we can do is we can continue this
Okay.
to our next to the May meeting, at which point you'll have to put that information in the package.
Sure.
And then we're going to go right back to the same question.
I caution that the deadline for re-adjudicating a matter has already passed.
Yeah, I see. And that's why it's before us now.
I didn't understand it was a re-adjudication request.
Oh.
It was just, I saw a new complaint file. Because usually a re-adjudication is not submitted on a new complaint form.
What is the deadline? Is it a 12 months?
I believe it's either 30 days or 60 days from the date of the order of determination
for a
for a request for re-adjudication
for
due
what's
to new information.
okay.
And I would definitely kindly ask that be waived somehow because that is not what I was told by Mr. Young. I was told that in order for me, I was never told that there was a time limit. I was told that in order for this to come up to what it is today, I needed to submit information. I never submitted that information. I never got a call from Mr. Young regarding this issue. It was just put on the issue today. It was a surprise to me, to tell you the truth. Although I had the information, but I personally was under the understanding that as soon as I put more information in, it would be then put on the calendar and then it would be heard.
Mr. Tedeschi, you haven't submitted anything to me.
Yes, I know. That's why I'm very surprised that it was actually on the calendar today.
But
I
you
thought
got a
the
notice, but you got a notice of hearing.
I did.
I got an email from you
I
that
did.
stopped mid-sentence, and I wrote you back and said, I'm not sure what you're talking about here.
Yes, I got that email response also, and I also had a phone call with Mr. Young, who actually hung up the phone on me. So after he hung up the phone on me, I said, you know what, let me just deal with this here, and that's why I'm here. But this is regarding the same thing, and I thought that was very unprofessional of him, although he's helped me in the past with Rosie, and I really appreciate you guys' help. But this kind of switching and
So,
is not helpful.
Mr. Tebes, I'm going to go back to 17057.
Yeah.
And I was on that, both the subcommittee and the full task force, and we spent a lot of time. I don't think you have anything new that's going to change that jurisdiction issue. I really don't.
Okay.
And it seems like mechanically we can't let you continue it because the statute of limitations has expired. You could file a new one, but then it be deemed as duplicative. Even if it's not, the first question we're going to look at is jurisdiction. It's probably going to fail
See,
again.
this is what I'm saying. This is done on purpose. This is done on
Not really.
purpose.
No,
this
it's
is
not.
unacceptable. It's unacceptable.
This
I
is-
give you guys. I have given you guys latitude. I've seen. I've seen.
Mr.
my-
Tedeschi,
I'm
wait,
going to
this is
interrupt.
unacceptable.
I'm going to
sorry.
interrupt you. So what you're doing is
It's just wrong. It's wrong. It's wrong.
you're in the wrong forum. We can't help you with this one. That's what we're trying to tell you.
No, I believe you can.
But what-
This has to do with information that is subject to a closed meeting.
Mr. Tedeschi,
That-
Mr.
it's-
Tedeschi, please take direction from the chair.
Mr. Tedeschi, I've asked that question and you answered it. This issue is not about the closed meeting.
I'm sorry?
This issue is not about the closed meeting, according to you.
No, it is. It's about a public meeting. A public meeting that happened. Portion of that public meeting is closed to
Right.
the public. They did not respect that portion of that, and that's what I'm basing my complaint on. I'm saying that they should not have given my private information about the closed meeting to a building manager who then leaked it to the press, who then, because of that action,
Was that
that I did not get.
17057?
I did not get.
That's already been.
I did not get a fair hearing.
That was heard at 17057.
No, not under the deliberate process privilege area of the law.
Let me try and summarize. What he's trying to argue is that because that package was linked to a closed
Yes.
public meeting,
Right.
Exactly.
he's trying to have it reconsidered under that. And we can't even get to the merits of that because we can't get past jurisdiction. Do you understand?
Yes, and I say-
yeah. What you're saying, I think, if and when you get the pro bono help, that's a question they can say, okay, under the law, CIPRA, whatever else, we can go all the way back and appeal that, and that's the correct path for this. We can't even get there to help you if we could.
But you could. You're talking about the RFPs. They always bring delivery process, excuses
I hear what you're saying.
all the time to you guys on other cases, not my cases, other cases.
Yeah.
And so
it's an interesting angle that you bring with the closed meeting connection.
Yes.
But we can't even get there to make that connection. That's where our hands are tied. And we've helped you as much as we can in your other cases. This one, I don't think we can. We really can't. So again, the choice is before you. You can withdraw it. Let me not withdraw it. Let me just have it go to the full task force, even if it dies there. Okay.
And then at least I'll be able to put in more information to the packet as much as I can and just do a Hail Mary.
Fine, let's do that.
All right.
So it's going to go to the full task force with recommendation that we don't have jurisdiction on the.
Based on current information.
Right.
Yeah.
Okay.
And Mr. Tedeschi's going
All
to
right.
provide. Okay.
Okay, thank you.
So that's a motion. Member Hinsey, can you second that?
Second, sure.
There's no public to comment on the motion. What? No, Mr. Harlan. All right, let's vote.
Member Highland?
Aye.
Member Highland, aye. Member Hensy?
Aye.
Member Hensy, aye. Chair Kanata?
Aye.
Chair Kanata, aye. The motion passes.
That's the last item on the agenda.
Yes, it is.
Okay, we are adjourned. Thank you.
Victor.